All right, we will call the Senate Judiciary to order. If the Secretary would please take the roll.
Senator Harris. Senator Orenshaw. Senator Dondera-Loop. Senator Wynne. Senator Hansen. Senator Krasner. Senator Stone. Chair Scheibel.
Here. Please mark those senators who are arriving present as they arrive, and Senator Krasner will be excused today. With that, we have one bill hearing on our agenda today, SB 222, which our Vice Chair, Senator Harris, will be presenting. Looks like she is ready, so I will go ahead and open the hearing on SB 222. Please go ahead whenever you're ready.
Good afternoon. Thank you, Chair Scheibel. Dallas Harris for the record, representing Senate District 11. I appreciate you all taking the time to hear Senate Bill 222. This bill is designed to increase the diversification of our juror pools. You cannot have a jury pool or jury that represents the community if you do not have a juror pool that represents the community. And so this bill does it in a couple of ways. One, it adds a new list to the lists that jury commissioners will pull from in creating the juror pool. It also increases the daily pay from $40 to $65. The last time this number was touched was in 2003, and it went from $10 to $40. We have not touched that number in 20 years. The $65 number that you all have before you in the bill is just the CPI adjusted number from 2003. So I think it's a small, reasonable step to make it a little bit easier for people to participate in the civic process. The bill also creates some equity between both civil and criminal cases with respect to the restoration of rights. And so under current law, a previous felon can serve on a civil lawsuit immediately, but must wait 6 years to serve in a criminal court case. Most states, from what I've seen under my research, do not differentiate between when those rights are restored. And so I made an effort here in this bill to also not differentiate. Madam Chair, I also have an amendment that I'd like to speak to, if that's okay with you. Great. So you all should have an amendment with you at your desk. It does two things. One, it makes it clear that just because you are eligible to serve on the jury, there is no guaranteed right. If you have implicit or actual bias, both sides should be able to argue that bias. It also makes clear that parties can inquire into the criminal history of a potential juror, and also clarifies that nothing in this bill further limits any of the parties' preemptory challenges. It also sets back the effective date in order to give the courts and the Department of Health and Human Services sufficient time to be able to establish a process for the transmittal of the list that I am adding to the list that they have to pull from. That is a big summary of the bill, Madam Chair, and I'm happy to answer any questions if committee members have them.
All right. Do the members of the committee have any questions? Senator Wynne.
Thank you, and I apologize for my tardiness and missing the first part of your presentation, but I appreciate you taking the opportunity earlier to talk to me about this bill. I know that currently we don't pay our jurors that are initially impaneled, initially called in and summoned. Are there any provisions to compensate those individuals yet, or are we still not compensating until people are in fact impaneled on a jury?
Nothing in this bill changes when we begin payment to jurors. I'm trying to take a small step. Frankly, I don't even know if $65 is really enough, and compared to other states, it's still fairly low. That's a great idea, Senator Nguyen, and if I could get the committee's support and this body's support, it's something I'd be more than willing to look at.
Always baby steps.
Other questions from members of the committee? Senator Hansen.
Thanks, Madam Chair. I'm not sure if it's a question for you or maybe somebody else. In a preemptory challenge, are they allowed to ask your previous criminal history?
Senator Hansen, I personally do not pick jurors in my practice, and so I will leave that to some others to answer if they'd like, but I can say this bill would ensure that you are allowed to do that.
Oh, you are allowed to. Well, that's one of the questions I had, because obviously when you're trying to select a jury, you want to make sure you know as much as you can about everyone, so you get hopefully and ideally, a fair judgment. So, but I don't know, maybe some of the people come up to testify can answer that. Thank you, Madam Chair.
We can have LCB legal confirm, but yes, questions about criminal history are allowed in voir dire. Other questions? All right, I don't see any other questions from the committee, so we will move to testimony. We'll start with testimony in support of SB 222. Anybody wishing to give testimony in person can come on down to the table in Carson City or in Las Vegas. And whenever you're ready, go ahead.
Thank you. Good afternoon, Chair and members of the committee. My name is Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. Thomas Jefferson said that I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution. Jury duty is an incredibly important part of our country, and it's the backbone of our Constitution. Ensuring that we have a fair set of jurors to sit and judge our clients is incredibly important, and we support SB 222. Thank you.
John Piro from the record, JOHNPIRO from the Clark County Public Defender's Office. We are in strong support of SB 222. To answer your question, Senator Hansen, we're always allowed to ask those questions. So both the prosecution will ask of criminal history, and people will actually have to go into full details in front of a panel of strangers that they don't know. Jury duty is a rather uncomfortable service, so this bill is good in large measure that it does provide higher pay for especially people who may not be able to do that. If you work at 7-Eleven and you're the owner of 7-Eleven does not pay you to show up to jury duty, you're taking a substantial pay cut for that time, and you don't even get paid for the first 2 days. So you could be there the whole time, maybe not even get picked for that jury and lose out on 2 days worth of pay. So this bill is a very good measure in that sense. It won't stop the prosecution from asking the questions that they want to ask. It won't stop us from asking the questions that we want to ask to find a fair cross-section of the community to judge the case. We have been moving in the right direction with jury diversity for quite some time with the help of this body, and this bill will even bring us closer to that. So we urge your support of this measure. Thank you.
Good afternoon, Chair and members of the committee. My name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We support SB 222 because we need to ensure that our juries are representative of their communities. A jury is meant to be a group of someone's peers, and this bill helps us move in that direction and diversify the jury pools. We have restored people's right to vote if they are no longer incarcerated. We should do the same for juries. They should be fully able to participate in the democratic process and serve on a jury as well. Having everyone participate in our processes makes them better. That and the other provisions will only make our judicial system what it needs to be, fair and balanced. Please support SB 222. Thank you.
Good afternoon, Chair Scheibel, members of the committee. My name is Andres Moses, A-N-D-R-E-S, last name Moses, M-O-S-E-S. I'm here on behalf of the 8th Judicial District Court in Clark County, Nevada. We are in support of Section 2 of the bill, which increases the fees to jurors, and we think that's long overdue. And we are thankful to Senator Harris for bringing that measure. In the 8th District, we are the busiest trial court in the state. We had over 25,000 jurors come through our doors last year, so we're very busy. I also want to thank the senator for working with us on the amendment to the effective date for Section 1. That'll give us plenty of time to work with the Department of Health and Human Services in implementing the additional source list to our jury pool. Thank you.
Thank you. Anybody else here to testify in support? Anybody that might be sitting in the fourth row that wants to come to the front? Okay. In that case, we will go to testimony by phone in support of SB 222.
Thank you, Chair. If you would like to testify in support of SB 222, please press star 9 now to take your place in the queue.
Hello, board. This is John Carlo from the young gentleman from Las Vegas, and I'm actually commenting in support of this bill, but I actually would like it to be more than $65 because of how much tax money the state has. And actually the tax money, we need to figure out a way to give them more money to the people, especially if they're taking off work. And that's all I have to say. Thank you.
Thank you, Chair. There are no other callers wishing to testify in support at this time.
All right, then we will go to testimony in opposition. Anybody wishing to speak in opposition is invited to the desk here in Carson City or in Las Vegas right now.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in opposition to SB 222. And I want to start off by saying that Nevada is not an outlier with respect to the opportunities for individuals with felony convictions to serve on a jury. As the law stands right now, people with prior felony convictions are eligible to serve after 6 years, and that is 6 years after they have completed their sentence. And over the past few sessions, DAs have supported efforts to help restore and reintegrate those with criminal histories into and back into society. We worked with then Majority Leader Ford and then Speaker Frierson in 2017 and 2019 on restoration bills, reducing the timeframes in which a person can apply for sealing and to allow a person not incarcerated to vote. Specifically in 2017, Nevada went from a near total lifetime ban on felons serving on juries to a 6-year ban on juries in criminal cases, and we supported that bill. And I think it's important to note that a majority of states in this country have a near total ban on persons with felonies serving on juries, unless their rights have been restored. Some states even extend that ban to misdemeanor crimes. Of states like Nevada that have a time period in their statute, most are longer than Nevada. A 10-year ban is the average for those states with a temporary ban on jury service after a conviction. In total, over 2/3 of the states impose a greater restriction on a person with a felony's jury service than what Nevada currently does. It's our opinion that we strike the right balance between understanding the inferred and implied bias an individual with a felony history has and the right of restoration that we all believe in. An individual with a felony conviction is someone who, at a minimum, has willfully disregarded and violated the very laws they would then be asked to apply and enforce as jurors, the laws on which our system depend. I'll also point out that this bill allows people with crimes of dishonesty, moral turpitude, sex offenders, and serious crimes of violence to serve on juries after completion of their sentence. Not even California goes that far. I will say I do want to thank Senator Harris. She brought us into discussions of this bill early, and her amendment does alleviate some of the concerns that the DAs have. I also want to point out that we do support efforts to increase the diversity of the jury pool, and we are in favor of the first two sections of this bill that both add other avenues for jury commissioners to seek increased diversity and to also increase the compensation that jurors receive. But with respect to jury service, Nevada strikes the right balance. We do not have a lifetime ban. We do not ban jury service for nearly as long as other states. The Nevada way is the right way. Thank you, Chair Scheibel.
And Mr. Jones, do you mind taking a question?
Of course.
Okay, Senator Nguyen.
Thank you, and I appreciate you probably reluctantly agreeing to answer a question I have about this. You know, I know that as a policy, this body and this legislature has moved away from some of these archaic laws, like most recently in previous sessions to restore felons' civic rights to vote. A lot of those laws, much like some of these jury restrictions, are rooted in some of those very old, archaic things like where only white landowners could be a part of juries and only women couldn't vote. And so we're kind of moving away from that. And I'm wondering what it is about the 6-year time period that, I don't know, like, is there something rooted in a 6-year as opposed to a 10-year, as opposed to a 6-month or a 1 year with that? And then I have a follow-up if you can answer that.
John Jones on behalf of the Nevada District Attorneys Association. The 6 years is what was in statute prior to the adoption of the bill back in 2017. So in terms of that specific number, we did not come up with it. But I will say that the 6 years is consistent with how we treat individuals with felony convictions in other avenues. I'll point out that a person with a felony is banned from possessing a firearm for life. They're banned from running for public office for 4 years. And I can impeach an individual with a felony conviction up to 10 years after they've completed their sentence. So this is how this is the law as it stands now, and I don't think that the 6 year is any inconsistent with the things that I've just mentioned.
And so you said you could run for office, so you could conceivably sit on this board and sit on this dais, and you could make decisions about the laws that you wouldn't be entitled to enforce after at least 4 years. Is that correct? And you can vote immediately upon your release from your sentence of imprisonment.
John Jones on behalf of the Nevada District Attorneys Association, that is all correct. It's 4 years for public office, it is 6 years for jury service, and you can vote instantly. But I would argue that there is a difference between those three things.
Okay. And then my other question is if this law was to be become law, you would still have the ability as a prosecutor to question people. You had mentioned something about how people were too close in time to their potential conviction or their service of their sentence to be fair, but you would be able to weed out those individuals, I guess, and through the process of voir dire. There's nothing in this law that prohibits you from asking questions about people's criminal backgrounds.
John Jones on behalf of the Nevada District Attorneys Association. I would argue that the way that SB 222 is currently written, that an argument could be made that the legislature has taken somebody with a criminal conviction, at least the fact that they have a criminal conviction, outside of the voir dire process. I will say that the amendment that Senator Harris has adopted does clarify some of that, and we are in support of that amendment, but it does not address all of our concerns.
Thank you for the indulgence, Chair.
Since you're in the hot seat, I'm going to allow Senator Hansen to ask a question as well.
Hot seat, huh? Just another witness, John. Hey, I oppose the idea of allowing felons to vote unless you have an extended window of time, things like that. So this to me is, as Senator Wynn pointed out, we have got away from some, but it's possible, too, to swing too far the other direction. We have all sorts of felony categories, A, B, C, and so forth. I can't remember which ones are like child molesters, rapists. Are they felony A's or?
John Jones on behalf of the Nevada District Attorneys Association. Certain sex offenses are A's, others are B's, so it depends. And some states do classify the ability to return to jury service by conviction. So in other words, in California, I believe they prohibit sex offenders from serving on juries.
Okay, well, that's what I was driving at. Look, there are some felonies that are, not as significant, if you will, as others. But in my mind, the idea of allowing a child molester, somebody who's convicted of severe domestic violence, rapists, things like that, I just don't feel comfortable having them serve on a jury. So maybe there's some way that we could come up with a way to break out the categories of felonies so that for the really rotten people that did some exceptionally nasty stuff, we would at least maintain a 6-year window before they can apply. So that would be something I would like to see possibly looked into, because that just doesn't sit right. And your point about, felons cannot have a Second Amendment right restored ever under our current way of looking at it is a disturbing thing too. At some point, I would think that we would again look at, you paid your dues, whatever, then after a certain window of time, even if you're convicted of a gun thing, you could have that civil right restored as well, the fundamentals of the Bill of Rights, Second Amendment. Thank you, Madam Chair.
I think that was more of a comment. That last part, at least, was a comment more than a question.
At the end, but he got a question in. I did.
Okay.
I did. It's like it's like you lawyers. I know you understand it. Like you have to make a statement at the end. You say, "Isn't that right?"
I just want to make sure that we're not missing, an opportunity to hear more from Mr. Jones. But if you're satisfied, then I will just mention that the types of maybe you could confirm that the types of offenses you're talking about, child sexual assault, murders, those are generally going to be life sentences. So even if that person were out of custody, serving a 20 to life or 40 to life, they would still be on parole. So they would not have finished serving their sentence and wouldn't be eligible to serve on a jury anyway. For the record, Mr. Jones is nodding in affirmation. And we appreciate you indulging us, answering our questions.
Madam Chair, I want to hear his answer, not just a nod. So
we appreciate you being here, participating in the process, and we will continue with testimony in opposition to SB 222. I don't see anybody else in person, either in Carson City or Las Vegas, so we'll go to the phone, please.
Thank you, Chair. If you would like to testify in opposition to SB 222, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to testify in opposition at this time.
All right. In that case, we will go to testimony in neutral on SB 222. Anybody wishing to testify in neutral is invited to the seat. And I see somebody in Las Vegas. Go ahead whenever you're ready.
Good afternoon, Chair Scheibel and members of the Judiciary Committee. My name is Mark Schifalacqua, SCHIFALACQUA, and I'm the head of the Criminal Division for the Henderson City Attorney's Office. And as this body knows, we are now doing jury trials for domestic battery in the Henderson Municipal Court. I did want to, speaking here in the neutral position, did want to just speak to the importance, though, in my opinion, of the inclusion of the amendment before you. And I do appreciate its inclusion by Senator Harris. As been mentioned, the point of jury selection is try to determine whether any prospective juror harbors any bias against one of the parties or the system in general. That bias could be expressed by saying you can't be fair, could be implied like you know a witness or maybe one of the attorneys on the case, or it could be inferred like you're similarly situated to either the victim in the case or the defendant in the case. And the only way to really effectively try to see if there's bias is to talk to people and to get in their past life experiences. Without the amendment to this bill, there could be an interpretation by the judiciary that the parties may never inquire into somebody's criminal history or felony conviction, the circumstances surrounding it, or it couldn't provide a valid basis to challenge someone for cause or to use one of your peremptory challenges. And although not every time, certainly, it is possible that a prospective juror may be similarly situated to the defendant, and that would be inferred bias as recognized by the Supreme Court. Other times, perhaps the felony conviction itself could show a aversion to following the law, like dissuading a witness from testifying or intimidating a public official. We would want to bring those things up and challenge those particular jurors. And that meant this amendment would preclude a judicial interpretation that I think would be rather unfortunate, that would limit the abilities to inquire into criminal history and to ask how it affected a prospective juror, determine whether there's a basis to challenge for cause or use a peremptory. And I would say that the amendment does address those concerns. And I did value very much my conversations this past week with Senator Harris, and I do appreciate the inclusion of this amendment. And with that inclusion, we are neutral on the bill. Thank you.
Thank you for joining us and testifying today. I don't see anybody else coming to the table either in Las Vegas or Carson City to testify, so we will go to the phone for testimony in the neutral position.
Thank you, Chair. If you would like to testify neutrally to SB 222, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to testify at this time.
All right, thank you. At this time, if the sponsor has any closing remarks, she can make them, but she doesn't. So that brings us to the conclusion of our hearing on SB 222. I will now close the hearing and move on to the last item on our agenda, which is public comment. Anybody wishing to give public comment will be able to speak for 2 minutes, either in person or on the phone. I'm not seeing anybody coming to the microphone in person, either in Las Vegas or Carson City. So we'll go directly to the phone line for public comment.
Thank you, Chair. If you would like to offer public comment, please press star 9 now to take your place in the queue.
Hello, board. My name is John Carlo, the young gentleman from Las Vegas, and I'm calling to update the board, but to also quote a Bible verse from the book of Matthew, chapter 18 and verse 16, where Jesus said, "For whosoever shall offend one of these little ones that believe in me, it were better for him that a millstone were hanged about his neck, and he was thrown into the depths of the sea." So I would like the Judiciary Committee to work on laws to help reduce the amount of human trafficking that is happening in Las Vegas. What Jesus actually teaches in the Gospel of Matthew is that these pedophiles should be thrown into the sea. Also, in the case of rape, the Bible teaches in the Old Testament, and these are laws. A lot of our modern laws are based on Bible. Our Constitution was based a lot on the Bible. So the Bible is actually a very good reference point. In the case of rape, the Bible says that if a man rapes a woman, he should die. And our tax dollars should not be going to keep these people alive. We should save the state's tax money, and let's use those tax dollars to reduce the human trafficking. Also, Sheriff Grady from Florida did a 2-year investigation on how LAX is shipping out methamphetamines out of their airport. And what I would like the Judiciary Committee to look into are state border checkpoints. Texas has state border checkpoints, but I believe because we're allowing so much car traffic into the states, we're allowing drugs to be rampantly being
That
poured
is
into
2
our
minutes.
cities.
Thank you for your public comment. That's 2 minutes.
Yes, ma'am. Thank you.
BPS, are there any other callers on the line?
Thank you, Chair. There are no other callers wishing to offer public comment at this time.
All right, then. That brings us to the conclusion of today's business. We will be meeting again tomorrow at 1 p.m., and until then, we are adjourned.